In this video, I will discuss Catalonia's bid to be an independent state under international law. In the 2010s, the dissatisfaction of the Catalan people with Spain rose, and it attempted to become an independent state and to secede from Spain. While Catalonia failed to become an independent state, it is still interesting to discuss whether Catalonia maybe had the right to become an independent state under international law. Whether this is the case will be discussed for the advisory opinion on Kosovo, which was presented by the International Court of Justice in 2010. When Kosovo declared its independence in 2008, the General Assembly of the United Nations were uncertain about the legality of the declarations of independence. As such, the General Assembly requested the UN's main judicial body, the International Court of Justice, to present their advice on this question. Is Kosovo's declaration of independence in accordance with international law? The ICJ determined that it had jurisdiction to answer this question and firstly analyzed that there is no general prohibition of declarations of independence in international law. International law has no rule prohibiting a people from declaring their independence. However, declarations of independence can still be illegal. This can be the case when the people declaring their independence violated general norms of international law in their fight for independence, or when the people violated a rule of lex specialis that is applicable to that situation. The ICJ interpreted the question in front of them very narrowly. They determined that they only needed to answer whether Kosovo could declare their independence, and thus did not answer whether there is a right to secession in international law, nor did they answer whether a legal declaration of independence would result in effective independence, and in this case, thus whether Kosovo would be a state under international law. There can be three important conclusions drawn from the Kosovo case. The first conclusion is that the ICJ considers that declaring independence is not the same as effecting independence. The ICJ considers that different sets of rules apply for declaring independence and for effecting independence and becoming an independent state under international law. The second important note from the Kosovo case is that the ICJ considers the principle of territorial integrity to be confined to the relations between states. The principle of territorial integrity, which means that states have the right to protect their territory and sovereignty, can only be violated by other states. This is an important remark, as this means that Kosovo in this case could not violate Serbia's territorial integrity, as it was not a state. The third important note is that the ICJ considers that a right to independence exists for those peoples subject to alien subjugation, domination, and exploitation. While this right is mainly created for colonial countries, it could open up more possibilities for other discriminated peoples. Before we dive into what this legal framework from the Kosovo case could mean for Catalonia's bid for independence, it is important to discuss the right of self-determination. The right of self-determination means that all peoples have the right to freely determine their political status and to pursue their economic, social, and cultural development. There are two different types of self-determination: internal and external self-determination. Internal self-determination is concerned and limited only to the relationship between peoples and its own state or government, and thus, for example, applies to those peoples living in federal states. External self-determination deals with secession from or the dissolution of a sovereign state, as well as association with or integration into another fully sovereign state. Internal self-determination is thus about having the right to determine your political status and to pursue your economic, social, and cultural development within another state, while external self-determination is about creating or being your own state to do this. Declarations of independence and the exercising of independence and becoming an independent state under international law can thus be seen to fall under the external scope of self-determination. The question is whether Catalonia has internal self-determination. Catalonia is currently an autonomous community within Spain through Article 2 of the Spanish Constitution. It has territorial autonomy and autonomy over some aspects of policy, which include economic policy, building and housing policy, and public health, among others. Catalonia also has its own parliament, and the Catalan people can vote for their representatives. As such, the Catalan people can determine their own political status and can pursue its own economical, social, and cultural development within Spain. Catalonia is thus exercising internal self-determination, and this internal self-determination is also respected by Spain. To become an independent state under international law, Catalonia will need to exercise external self-determination. On the 1st of October in 2017, Catalonia held a referendum in which it posed the question whether Catalonia should be an independent state. 90% voted for independence that day, although the turnout was only 43%. On the 27th of October, Catalonia declared its independence. The Spanish Constitutional Court called the referendum to be illegal and also called the Declaration of Independence to be illegal and unconstitutional. Spain's government also took over some of Catalonia's autonomous powers following the Declaration of Independence, which were returned when Catalonia's new government came to power in 2018. As Catalonia received no support from the European Union and no state has recognized Catalonia as a state as of 2024, the alternative route of gaining independence through recognition from other states is also not a success. As such, Catalonia has failed to exercise external self-determination. However, this does not necessarily mean that Catalonia's declaration of independence was illegal under international law. The Kosovo case has taught us that there is no prohibition of declarations of independence unless a violation of general norms of international law occurs. These norms include the non-use of force, the prohibition of aggression, the prohibition of genocide, the prohibition of crimes against humanity, the prohibition of slavery, etc. As Catalonia attempts to achieve independence from Spain by holding a referendum and negotiating with Spain, and has used no violence against Spain, Catalonia has not violated a general norm of international law. The Kosovo case also stated that a violation of rule of lex specialis would mean illegality of a declaration of independence. As there is no lex specialis on the situation in Catalonia, this means that Catalonia also cannot have violated any such rule. This means that their declaration of independence is not prohibited. Concluding, Catalonia's declaration of independence does not violate any rule of international law and must thus be considered to be legal. The question is now whether this means Catalonia should also be allowed to exercise their external self-determination and have effective independence. As it was mentioned earlier, the ICJ has created a difference between declaring and effecting independence. Every people is free to declare their independence, but the effectiveness of this independence depends on other rules and factors. While Catalonia cannot violate Spain's territorial integrity, as it is not a state, the 1970 Friendly Relations Declaration contains a safeguard clause, in which it is stated that a people has no right to external self-determination if the state that people belongs to respects that entity's right of internal self-determination. Applied to Catalonia, it can be concluded that Catalonia has internal self-determination and that internal self-determination is respected by Spain. Catalonia is also not a colonial people and cannot be considered as a people subject to alien subjugation, domination, or exploitation, and thus does not gain the right of independence through this. As such, Catalonia does not have the right to exercise external self-determination. To conclude, Catalonia can be considered as having internal self-determination. It has, by declaring their independence, not violated any general norms of international law, and their declaration of independence must thus be regarded as legal. Their internal self-determination is respected by Spain, and they thus fall within the scope of the safeguard clause from the Friendly Relations Declaration. Catalonia does not have the right to exercise external self-determination. Catalonia has also not been recognized by any other state, which also blocks the alternative route to become an independent state. As such, the conclusion is that the Kosovo case does not present Catalonia with the right to exercise external self-determination and to become an independent state under international law.